ஒரு மகிழ்ச்சியான செய்தி. இதயம் நல்லெண்ணெயின் விலை லிட்டருக்கு ரூபாய் 105 குறைஞ்சிருக்கு. செப்டம்பர் 2023ல 1 லிட்டர் இதயம் நல்லெண்ணெயின் அதிகபட்ச விலை ரூபாய் 503. ஆனா இப்ப 1 லிட்டர் இதயம் நல்லெண்ணெயின் விலை ரூபாய் 398 மட்டும்தான் தமிழ்நாட்டுல. அப்ப இனிமே எல்லாரும் இதயம் நல்லெண்ணெய் வாங்கலாம் இல்ல?
When Ravi asked me, I immediately said we will meet. I thought 10 of us are going to discuss. In 10, we can always speak very freely and it would not be recorded. So I said that I can speak my mind out. During 1975, இந்த பாரதியார் சொல்ல எல்லா இடத்துலையும் எழுதுவோம்னாங்க, இம்மென்றால் வனவாசம் இல்லா சிறைவாசம் அவருடைய வார்த்தைகளை எல்லா இடத்துலையும் எழுதுவோம். இப்போ கிட்டத்தட்ட அந்த ஸ்டேஜுக்கு நாட் பிகாஸ் ஆஃப் த கவர்மெண்ட் but because of other forces we are facing a situation today. I don't intend to dissect this judgment and tell you what it is all about, except to take you some paragraphs and show how if you look into it, the whole problem today is, after I have completed 50 years in the bar now, if you ask me, have you read the entire Keshavananda Bharati, I have not. I do not know how many would have read the entire Keshavananda Bharati and found out what it has been said. When huge volumes are written, the core is lost. The essence is lost. And people can pick 2 sentences from here and 2 sentences for them and misquote. If any one of you have read the novel of Irving Wallace, where he wrote about what is meant by obscenity, the novel பேர் மறந்து போச்சு, J.J. Jadwin ஒரு லாயர் வருவான். Cross examinationல the priest will be put into the box. So this man will ask him, show the one paragraph and ask him to, he will show him at the passage and ask him to read and ask the priest, do you think it is obscene? The priest will say, undoubtedly it is obscene. They will show another passage and ask him to read and he will say it is not obscene. Then he will tell the priest, the first paragraph which you said obscene is from Bible. The second passage which I showed to you is from Lady Chatterley's Lover. You will remember that was a banned book about 150 years ago. The angle through which we see is what matters. But when such huge volumes are written, if you take something out of context, it will give you completely a wrong meaning. What I intend to do was, அந்த இடத்துல எழுதும்போது அதுக்கு மேலே சொல்லியிருக்கக்கூடாது. அதில் அந்த இடத்த தனியாக பிரித்தோம்னா it will give you altogether a different meaning. So when you write whole number of things, we normally lose the sequence part of it. And when one paragraph read in isolation will convey a different meaning. That is always a difficulty in the present day judgments. As a person who entered the bar in 1974, the judgments up to 1965 Madras used to be very sharp, very precise. Justice, all is said and done. Justice K. Veeraswamy, Satyanarayana, everyone's judgment was very brief and good. Then what is the purpose? The purpose is to awaken. To awaken and find out how best, or can we go there and go to the Supreme Court, all of us fight? No, it is not possible. Legally, people will be working out what should be done. But that shows that we as lawyers and we as citizens of India must be very conscious of what is happening around us and form public opinion to make the court think that a decision of a particular nature will not be to the general philosophy subscribed by the vast majority of the citizens of this country. It is the formation of that opinion becomes important. Why I am saying this, when I conclude, I will tell you, I'll conclude, that much I can assure you. So when I conclude, I will tell you why I am making this statement. Now the whole thing happens because, let us understand what is happening. A few statistics which I read is quite interesting. I found that prior to 1990, the universities in Madras, the colleges in Madras were ranked high, they were performing better. After 1990, there is a slide. And in this context, when I was holding the post as Additional Solicitor General, I had to represent the chancellor in a dispute where the then government, I am not talking politics, I am not accusing any political party as such, when the then government, not the government, one particular minister, one particular secretary proceeded against the then Vice Chancellor, Mr. Surappa, with whom I developed a great intimacy thereafter, and I appeared for him in several matters. Fortunately for the step I took, and my friend N. Vijay Raghavan, who is a prolific writer, he took it upon himself, fought that litigation, and we got an order that entire issue was closed. Because it came in the papers at that time, I do not know how many of you are aware what was the problem. The problem was simple. The minister and the secretary were utilizing the entire machinery of Anna University for their personal purpose and booking in the accounts of Anna University, which this man said from tomorrow onwards we will not do it. They got hold of a servant maid and said, this man said something which involved a foreign travel. In investigation it was found out the person who is said to have made that statement, they have never seen a passport in her life. So this kind of a problem, when does it arise? When you have got a right to interfere into the working of the university. Because the whole thing came only from the Vice Chancellor's bill, Chancellor's bill. I am stating there are other acts also which were taken up to the Supreme Court. Under the Madras University Act, let us take, the Chancellor has got a right to appoint a nominee. Syndicate, Senate. It can be said that the Chancellor, who is the governor, is also a political person. Maybe from a political party owing to a particular ideology, it can happen. I never say it cannot. But when he holds that office, he would not be speaking on behalf of that. If he does so, automatically he will become unpopular. I can give you the list of such governors who became unpopular and went also, we know. Therefore, there is some kind of an interest shown in academics. I would make one more preamble. In 1977, when I was a rookie in the bar, I was closely associated with Professor Swaminathan, who was the head of the Department of Commerce in Christian College, Madras, with whom I have got a great respect, but man's ability was absolutely stunning. He will be with us at 10:30 in Mylapore talking on the nationality, that nation is important, geographical barriers are there. At 2:30 he will be speaking with seeing eloquence in a communist meeting also. But that man's ability was extraordinary, but I always liked his knowledge and normally the way he acted. He was the president of Association of University Teachers. So I used to hang on with him, go with him. Because of this emergency contacts, I used to work with him. Even otherwise, he was my lecturer in Loyola when I entered Loyola College. There was a professor by name Deva Prasad in New College. The New College, it consists, the trustees were all extraordinary persons holding high position in life. They had some problem. They told this man, they interfered in the manner in which the academics was conducted, this, that, etc. This created a small problem. The management made a mistake. In one of their important functions, they asked Mr. Deva Prasad, who was the head of the English department, to come and speak. He got the mic. So he said something out, academics can be improved. And he said, your concern is that New College is not performing well. It can perform well, provided we concentrate purely on imparting education, making those children, all my students are good, all my students are competent, that we can do, but all that we require is, he made a crucial statement. He said, leave the academics to us, the academicians. Take care of your business. Walk away with your money. Next day morning, he was dismissed from service. So that was my first experience where behind the screen, I conducted a domestic inquiry. But strangely enough, at that time, the person who really gave me a lot of support was our N. Ram of Hindu. So when he came there, this went into my mind. When he said, our students are good, our lecturers are good, give us the freedom, we will get you the best children. Don't interfere. So I take it that in academics, politics should not come. Now, how did the problem start? Under the Vice Chancellor's appointment came, The question arose, who would be nominating? The present ruling dispensation said this is how it should be done. And definitely, the present chancellor must have had an occasion to look into the records of the previous chancellor, would have gone through the records of the Anna University, which I told you, must have formed some idea. So he was also very either adamant or obstinate. He felt that it should not be allowed to the politicians to enter. In this context, of course, the problem arose. If you ask me whether what the governor should have done, it is something very private. He could have done 100,000 things, but definitely I had a few occasions to meet him, a very, very learned man, I'm telling you, he's so sharp. 2 sentences he can understand. More than that, he's a voracious reader. He can understand everything, but he took his own conclusions. The matter went to the Supreme Court. The Supreme Court could have said, yes, this is how I construe Article 200. This is how I construe Article 201. And 200, what you should have done is, you should not sleep over the matter and then send it back. This is what the Supreme Court could have said. But Supreme Court went one step above. And if you look into it, it's a kind of a sermon that has been given, a beautiful sermon that has been given, and ultimately not stopping with that, one man came to you. You informed that every governor shall be informed. Every High Court judge shall be informed. I presume all High Court judges read all judgments that is circulated to them or not. Whenever they get an opportunity, we invite their attention, they all read. One thing that really struck me was, when Supreme Court, whenever it remands a matter to the High Court, if I am not mistaken, subject to correction from all my friends, they say the High Court is requested to consider and take appropriate decisions. They never give a direction. This is one constitutional position, that is one constitutional position. Many of the sitting High Court judges do not say that the subordinate judge is hereby directed. Many of them say that he is requested to dispose of the matter expeditiously, where there is a hierarchy mentioned. Now look at one constitutional machinery, Supreme Court, informs many other constitutional persons, better read what I told her, that is the law of the land, read, act accordingly. This is what it comes to. Now therefore 200 and 201 are to be taken. If you look into the judgment, trying to, because this 414 I could not download. If you look into it, I'll just tell you what he talks with matters pending with the governor. He writes, in view of the reservation of 10 bills for the consideration of the president, the petitioner filed IA number dash on 11/12/2023, seeking the amendment of prayers of the present writ petition and prayed for an insertion of the following prayer. The bill to amend the university's law, then the amended prayer is returned. Thereafter, I'm sorry, did it say something? I didn't hear. This court issued notice on 10/11/2023. The governor forthwith took a decision on 12 bills on 13/11/2023 by withholding assent solicitor to 10 bills. He did not convey any message to the state legislature for reconsideration of the said bills as prescribed under the first proviso to Article 200, and by reserving 2 bills for the consideration of the president, the 10 bills for which assent was withheld were returned to the state legislature by the governor. Now this 10 included the university bill, some files with regard to the sanctions to be done, etc. has not been considered. If you look into 200, it consists of the main provision and controlled by 2 other provisos. I don't propose to just dissect it, but for the purpose of clarity, if you look into Article 200, just for you to recapitulate whatever you might have read and probably in the newspapers too, when bill has been passed by the legislative assembly of a state, or in the case of a state having legislative council, has been passed by both houses of the legislatures, for us it is only one, it shall be presented to the governor, and the governor shall declare either that he assents to the bill. Next word is, or he withholds assent therefrom, or that he reserves the bill. Three scenarios emerge. He can give assent, he can withhold the bill, or he can say, I am reserving the bills for consideration of the president. Three options are open to him. You will find the word returned is not found in the main section, the main article. Main article does not say the governor shall withhold or return or send it to the president for his reserve for the president's intention. It uses the word merely withhold. Then if you come to the first proviso, provided that the governor may, as soon as possible, it is this sentence which created a problem. As soon as possible, after the presentation to him of the bill for assent, return the bill. If it is not a money bill, together with a message requesting the house or houses will reconsider the bill or any specified provisions thereof, and in particular will consider the desirability of introducing any such amendments as he may recommend in his message, and a bill is returned, the house or houses shall reconsider the bill accordingly. And if the bill is passed again, the house or houses, with or without the amendment, and presented to the governor for the assent, the governor shall not withhold the assent therefrom. Then there is a second proviso. Provided that the governor shall not assent, but shall reserve for consideration of the president any bill which in the opinion of the governor would, if becomes a law, to so derogate from the powers of the High Court or as endanger the position with which the court is by its commission designed to fill. So third position is it's being sent to, the second proviso deals with being sent to the president. The first proviso deals with returning. If returned, once again they send it back, yes, it becomes a law. In other words, the governor becomes like a house of elders where a bill is sent to them. They can ask the Lok Sabha, you please reconsider it. If Lok Sabha does not reconsider it, and if the Rajya Sabha will let it pass it, it becomes a law. What is the scope of a governor then? What is the object of a chancellor? The governor has to merely look into it and tell them, maybe you can change this word may or shall, probably don't do like this. They may accept, they may not accept. It is not, I don't think it can be even exalted to a level of advisory in nature. In other words, it is a pass-through. The bill will come, my man will say, and when I talk about this, I am only reminded of I don't know how many of you would have read this book of Rise and Fall of the Third Reich by William R. Shirer. It's a wonderful document. Similar position came to our great Adolf Hitler. When somebody told him, no, these people will object to it, he said, what provision is he doing? He said, these are the provisions in the Constitution. He just called the secretary and told him, amend the famous Constitution, and just walked out. It was amended immediately. 33, he became the Chancellor of Germany. 39, we know what has happened. This is the stage in which it can be done. But can the governor be merely, to use the word which all the speakers in 1975 used, is the president a rubber stamp? Or is the governor a rubber stamp? If you look into any of those papers or articles in Tukla, or probably Indian Express of 1975 to 77, this word you would have come across 100 times. And our great Rajmohan Gandhi used to repeatedly refer to this, the president has become a rubber stamp to the then government. Now therefore there has to be some purpose. So when I read it, when I had the necessity to read into it when I was holding this post at that particular point of time, I said that the word withhold must have some other connotation. I said if you want to harmoniously construe and find out there is no repugnancy between the main provision and the second provision, I said withheld itself means returned or rejected. It is only either of this. When it is rejected, he may send a message to the government, no, please change it. If he decides that there is no point in sending the message at all, if a student scores only 10 marks, whatever I may try, he will not cross 50. What is the point in telling his parents that please ensure that he passes? When I know that the teachers know it cannot happen, they will stop. They will not communicate. It could be that position. Anyway, the Supreme Court has construed it completely different. They did not consider it in this sequence. They said returning specifically only in first proviso, you would have done that, and as soon as possible. You did not do it for so many months. We issued notice to you, then immediately you referred it to the president. Indirectly, they attributed malefice. In my understanding, indirectly, they attributed malefice. Now this takes us to, under 201, which is the power of parliament, you will find it is not there. This distinction of providing a first proviso, second proviso is conspicuously absent. But Supreme Court has said, you, the president, will also be bound the same way as the governor is bound under Article 2. That is the ultimate decision, as I understand it, or somebody else. வேதத்துக்கு பல பாஷ்யங்கள் இருக்கிற மாதிரி இதுக்கு பல விதமான commentary வரலாமா இருக்கலாம், but I do not know. As I understand it, this is how I understand it. நான் எப்படி யோசிச்சு பார்த்தேன், tomorrow, if somebody says, very extraordinary, I am trying to extrapolate to an extent to find out how far this logic will hold good. The president has the power to pardon, and I think under Article 61, and the president is 62 or so, and governor is under Article 72. Some accuse, and I got a very interesting statistics for you, which I requested my friend to look into it. I will tell you what would be the impact of this judgment. Let us slightly move out and say that this is a law that has come to stay. Mr. Rajendra Prasad, he received 180 mercy petitions. Number of mercy petitions rejected 1. I do not know how many he allowed. We will come to the list. K.R. Narayanan, number of petitions accepted 0. Number of petitions rejected 0. In other words, it is not that there were no petitions. There were previous pending petitions were there. He just left over. He did not do anything. He just kept quiet. Allowed that fellow to languish in the jail, or probably served his sentence, or he died in this. Then the person whom we respect, Abdul Kalam J, PPJ Abdul Kalam, he allowed 1, dismissed 1, others he did not pass any orders. Now can accused come forward and say, you, the president, I have given you a petition for pardon. It is pending with you for 2 years. As soon as possible is not there. But there has to be some reasonable time. If you are not able to do it within 1 year, I am deemed to have been pardoned. I will come out of the jail. I mean, though I am pitching it as, that's why I said I am just extrapolating it. Can such an argument be advanced? I as a lawyer would think I will advance. Why is the governor was so reluctant to consider this? The reason is not far. As I told you, he has got a lot of information. He has got his own intelligence. He collects information, calls the Home Secretary, calls for records of various groups, and we all know what happened in various vice chancellors, the raids conducted, etc. All of that we read in the newspaper. He must have had an intention that handing it over to the ruling party or the leader of the ruling party, it would be disastrous because it would be filled with the political appointees and it may affect the academics. Because under entry 66 of your list 1 to the Constitution of India, education and higher standards belong to the central government to participate. If this appointment of a vice chancellor is going to adversely affect into the syllabus, the education system, naturally the governor would be concerned. Can it be said, you the governor, irrespective of the consequences, please close your eyes, give me one suggestion, I don't accept it, it becomes a law. Then the next thing that immediately came to my mind was something more interesting. NEET bill, the government which brought the NEET is not now interested in the NEET. The present person who are fighting against the NEET were a party to the whole process when it started, and it was taken by the Supreme Court and it was decided by the Supreme Court, then we are following it. He passes a legislation saying that please reject NEET, it is not applicable to us, we are a separate country all by ourselves. Let us take it. It goes to the governor. Now governor tells him, look, according to me it is not proper. You are now violating the very constitutional law, therefore reconsider it. 170 MLAs say, sorry the governor, we have now decided it is the law. Now the governor, as per the judgment, it becomes the law the day after. This matter is challenged in the Supreme Court. Supreme Court will say, what is this? We created it. It is our judgment. Your bill is exactly contrary to what we have said. We have already told you NEET has come to stay here forever. Supreme Court will dismiss it. Now, Supreme Court, all judges have taken oath on this constitution. The governor has also taken oath on this constitution. This governor says, I will act as per this constitution because you have laid down the law, I want to obey it, I am rejecting it. Supreme Court says, I have taken oath on the constitution, therefore I will decide it is bad. Is there a conflict or not? Are you not depriving a person who has taken oath on the constitution and become the head of the state as per the constitution, the chief executive, and tell him, you will not exercise the right that is available to you in the constitution by passing a law which is absolutely wrong? Let us go back in terms of memory. We are now in the 50th year of our emergency. On 12th June 1975, Allahabad High Court delivered a judgment declaring Mrs. Indira Gandhi's election as not valid and she was dethroned. She went to the Supreme Court. One of the great judges of our country who writes pages and pages gave a very interesting interim stay order. Madam Prime Minister, you will be the Prime Minister. You will go to the Parliament. You will discharge the functions of a Prime Minister, but please don't vote. You should not vote. You can participate, do anything you want, but you will not vote in the court. She was not very happy with that. On 26 January 1975, she declared emergency. Various laws were passed. One particular law was, when a person becomes a Prime Minister, does something, there is a complete immunity, nobody can ever question it. It was approved by the President, if my memory is right. Now tell me, if such a legislation is passed by the state legislature, giving immunity to Senthil Balaji forever, for all time to come, for the past, present and future deeds, as we used for the definition and consideration, past, present and future, if a pardon is given by saying that he is completely immune, sends it, governor says it is incorrect, goes back to the governor, they say sorry, past. What happens? Are we to take this paper, run from court to court and tell them you are wrong? Normally in a constitutional matter you will not get an interim stay also. He will definitely enjoy. Are not such possibilities there? The constitution does not say within what time a court should deliver a judgment, except the subordinate courts. I don't think there is a provision in the constitution, or probably the Supreme Court rules, I do not know, I have not practiced in the Supreme Court. It does not say a judge who reserves a matter should deliver the judgment within such and such a time. We had one Chief Justice who delivered the judgment after 3 years on the date of retirement. Maybe you would recall it is a CMC College case, which came to be set aside later, reviewed by the bench, 3 years. Can the litigant say, within 6 months you did not deliver a judgment? Shall I deem it that it has been allowed? Or shall I deem it is dismissed? This kind of an argument, though appears to be absolutely kiddish, pedantic, appears to be something far-fetched. What prevents us from saying that this will not be the argument tomorrow in a court? If you look into this judgment itself, there were two judgments that came before the Supreme Court. One is, let me just try to find out, I forgot the name, one came from, there was a conflict between two judgments. The Supreme Court resolved the conflict by saying there is no conflict at all, we find that everything is fine. I will tell you what it is. It is Velluri Basavaiya Chowdhury is one judgment. And the other is State of Punjab with something. Both State of Punjab, Justice Padiwala was one of the authors to this judgment. So they said, your State of Punjab is direct conflict with Velluri Basavaiya Chowdhury. Then they went into the question, is that ratio decidendi or arbiter? And he writes in the judgment in between, forget whether it is ratio or arbiter, I asked the petitioners, how do you distinguish and safeguard yourself? They did not answer. I asked the state of Tamil Nadu, I asked the council appearing for the union. They did not answer, or for the chancellor, the governor, they did not answer it. But I am telling you what the answer is. And he gives completely answer saying that if this argument accepted, this would be the consequence. We are not going to dissect it. Therefore, there were two judgments available. Now, what he could have done probably, and what he ought to have done, is go under Article 145.3. 145.3 because this is a matter, for the first time it's coming. The Supreme Court has said very clearly we have a problem in this matter. There are two conflicting judgments on view whether it is arbiter, ratio, decidental. Let's forget all these legal jargons, and there is a problem in this. Therefore, 145.3 says the minimum number of judges who want to sit for the purpose of deciding any case involving a substantial question of law as to the interpretation of this constitution or for the purpose of hearing any reference under Article 143 shall be 5. When the Supreme Court delivered the judgment, they said every governor shall read, every High Court judge shall read. I take it that it is something very serious interpretation of the Constitution. Forget everything else. The Supreme Court considers a very serious interpretation. Should not have been the procedure or referring it on Article 145.3 taken place. They should have gone there. They did not do it. That is one aspect of it. I'll tell you something more interesting. Again, subject of, please correct me if I am wrong. I think when the Supreme Court started, the total strength was 7 or 8 judges only. 7 judges. At that time, they said Constitution bench will consult for 5. No, it is 30. Should not proportionately that must also go up. When for Golaknath, 13 judges sat and decided. Such a serious matter. You are virtually castigating a person who is holding an office and who is discharging the function as the head of a state. You are imputing motives to him. Should it not be heard by a larger number of judges? He should have. They did not do it. Now what they did is, under 200, does it say that if the order, the rejection is not done or it is not accepted, within a reasonable, within as soon as possible, that is the moment it reaches you, it is as soon as possible, it is done, it shall be deemed to have been accepted. The word deem is a legal tool to create a legal fiction. A legal fiction means a particular state of affairs do not exist, but we will assume that it exists. When we assume that it exists, it shall be taken to its logical conclusion. In that logical conclusion, you will say that as far as it's concerned, these are all the results of such acceptance. I was wondering whether the word of deeming, you can use what is called as a causus omissus. When the legislature passed a legislation, if that particular provision is read, it does not actually convey the meaning it ought to, or it does not reflect the intention of the legislature, and the legislature is not correcting it, the court can say, we supply a word in this, and when it is supplied, this is how it would read. In other words, the court supply a word to a particular provision and construe the entire provision in the light of the word that they have inserted. This is called as causus omissus. This is normally applied for the purpose of interpreting ordinary legislations passed by the parliament, not the legislation which created the parliament. Constitution is the creator. Parliament is the created one. Can you employ the tactics? The extent I did a little research yesterday and today, I find that it is not possible. Even there are articles in the United Kingdom, even they have unwritten constitution, they say it cannot be done. You don't employ that tools. Causus omissus, they have freely said, no, we will consider it, and we have no supply to it. This, according to me, is yet another matter which definitely deserves our consideration. Can you assume and introduce a word there which is not there? If you are looking for where, the recent past, if you look into where this causus omissus came, originally the Prevention of Corruption Act, the word public servant was defined in a particular way. Then the matter came up of Global Trust Bank. In the Global Trust Bank, forgot his gentleman's name, I said, chief man, along with the executive director, Ramesh Gelli. Ramesh Gelli and the Subhasri were there. They were prosecuted under the Prevention of Corruption Act. So they went to the Bombay High Court. They said, look, I am not a public servant. Look into the judgment of Federal Bank. Global Trust Bank is a private bank. Merely because you took over to the Oriental Bank of Commerce, it will not become a bank, a state within the meaning of Article 12, when these offences are said to have been committed, I am not a public servant, therefore I am not liable. On taking cognizance by the magistrate, the Bombay High Court struck it down in revision, said, sorry, your PC Act will not apply. Matter was pending in the Madras High Court. The prosecution took it to the Supreme Court. I don't remember where. Judge Supreme Court judgment. That, he wrote a judgment that the object is to get hold of those corrupt people. And if I were not to apply, read the legislation to achieve its object, it would be incorrect. Give a score of reasons, and he said, I am supplying this word, it includes private company also. And immediately prosecute. It can happen because the object was different. Now, in order to look into it, how did the Supreme Court proceed? They went from 1891, they went to 1909 Act, they went into Government of India Act 1919, they went into the Government of India Act 1935. In all these things, the word was there, what should be done. That particular word was omitted in the Constitution. Therefore, they said, from all these things we infer that it should be done immediately. The word as soon as possible was not there. Rejection position was there. The governor had a lot of position. So they analyze all the entire history and come to that conclusion. But if you look into the Constituent Assembly debates, I'm telling you, those debates was really astonishing. We definitely had great sterling characters. Once again, here and now I will tell you my personal experience also. When I asked a very good gentleman, saying that you come from a family from both your father's side and mother's side, I'll tell you, Mr. Rajmohan Gandhi, I asked him, on the one side you are Rajaji's grandson, on the other side you are Mahatma Gandhi's grandson. Both of them fought for freedom. In your opinion, why do you think we have failed in our life as a democracy in this country? When we became independent, why were not we able to achieve what we would have achieved despite the brilliance of people who were there in the Constituent Assembly? He thought for a while and he gave me a very interesting answer. He said, all our leaders before independence had a wonderful collective wisdom as to what the Britisher must do. We did not have even an individual wisdom as to what we should do thereafter. That is the only way I would reconcile. I think about it, I completely agree with him. In the sense, there has to be collective thinking that is not there. This is what leads to the problem. You look into the anomalous situation that will arise because this has happened here. Many people say if it is not done, it is deemed to be done. Now, if this, therefore I told you about the pardon. Now, if you look into the other points, the basic structure. The fundamental point of basic structure is, you have got Parliament on the one side, the judiciary on the other side. Parliament passed the law. It will be tested by the Supreme Court in terms of the Constitution. No morality, nothing, but they will simply test it on the basis of the Constitution, legislative competency, arbitrariness, manifest arbitrariness, so on and so forth. That is all that they are going to do. But can this basic structure of one overruling the other? If you ask me whether such situations have not come up earlier, it has come up earlier. From 67 onwards, if my memory is right, from Madhya Pradesh, a speaker's case went to the, every time the conflict arises, there is some kind of a settlement. The last such case was our Ananda Vigadan, Mr. Vasan, Balasubramaniam. In 1990 or so, the 1991 probably, no, before that, during MGR's time, he was proceeded for a privilege, breach of privilege. That matter came up. That was the time, then again it was solved, because yes, you are right. Because in that privilege, Cho was summoned to the assembly. He readily agreed. He said, I will appear before the privilege committee. Then I believe MGR told the speaker, don't invite him, that will create a further problem, just drop the proceedings and walk out. So they walked out and they gave up the whole thing. Now therefore, such things have always cropped up. But wherever it cropped up, they found out a balance. After all, the fundamental principle of our entire constitution is the theory of checks and balances. Now what happens to the checks and balances? You have told them, I am superior. The other man will say, I am superior. The conflict begins. Where will it end? Is Thomas Becket being repeated is the next question that I ponder within myself. I do not know how many of you have heard about Thomas Becket story. So the king brings his best friend as the head of the church, Thomas Becket. he thinks that the best friend will help him. For some reason, the best friend decided to part ways with the king. There was a conflict. The question arose whether the church is superior or the kingdom is superior. The king had the army, so he just beheaded Thomas Becket and finished the story. Now what happens in the process, separation of powers came, they said church shall not interfere in the state. Separation of powers came, I think it was Henry, some years, old story, 1200 probably or so. Thomas Becket, it's a beautiful story, but this is real. He was beheaded. People who have gone to London have told me they have seen the chapel where he was beheaded. That place is still maintained as a monument. Anyway, places of execution, I always think a monument place only. Now that really makes us bother. What are we supposed to do? What are we supposed to do? The only thing that we can do is to say that we have to be cautious in our protecting our rights. We have to be cautious. The reason is all political parties, I am not saying that one party is excluded, all political parties never decide any particular problem on the basis of the issue that crops up at the problem, but every issue is looked from the lens of that particular political party and not in the nation's interest is the problem, is the first problem. It is very difficult to make all people say, no, let us hereafter think how we will go about it on issue base. Supposing something happens in the country and that is not good for the country, that is not good for our citizens, all political parties must join. It is not something that did not happen. 1971, 3rd December, Pakistan declared war against us. Our army was immediately rushed and Mrs. Indira Gandhi entered into a pact with Soviet Russia saying that you need to help us. Soviet Russia immediately agreed. That was required at that time because the minute the battle started, in order to scare us, the United States moved its 7th Fleet to the Indian Ocean. 7th Fleet is one of their biggest fleets with aircraft carrier and all. So I remember one of the general was asked this question at that time. I was a second year student, but first year law student. He asked him, 7th Fleet is moving, General, what do you propose to do? Do you think I can go and destroy it? I cannot. So let it come, we will see. We will fight it out. That is what he said. But Soviet presence helped us a lot. At that particular point of time, when the war broke out, all our political parties, to the extent I can recall, came under one banner and stood behind Mrs. Gandhi. And if I am not again mistaken, Atal Bihari Vajpayee said, Madam Prime Minister, you did not only create history, but also you created geography. At that time, I'm a great admirer of Rajaji. He once said when this whole battle was about to begin, by the time I think he passed away, he said, he first 47 partition came, he said that country is geographically apart. 25 years they will not be together. After 25 years, exactly 25th years they separated. So when this battle, when she entered into a pact, an anti-communist Rajaji said, fine, today he is helping us, we must be with him. But you must take a decision. You cannot say non-alignment, I will also be your friend, I will also be your friend, and everyone will become your enemy. So you took a right decision, somebody will behind us, and Russia stood behind us completely. But of course we paid the penalty in 1971 election, that is a different issue thereafter. But what happens is, the unity that we showed, but even then Raja said, even Bangladesh will not be friendly to us after 25 years. We are seeing the result now. Now the issue is coming under one banner. We all came under one banner. 62, when the Chinese war came, I do not think all of us came under one banner. At least in Madras we had some issues involved, if my memory is right, and also the communists did not support us wholeheartedly. The communists were arrested, imprisoned, but even then there was one IAS officer who wrote to Jawaharlal Nehru in a note that you cannot imprison the communists merely because he is a communist, he could still be a patriot. It was Airavada Mahadevan. It was Airavada Mahadevan who wrote this note, and he was worried that Jawaharlal Nehru will kick him out. Jawaharlal Nehru praised him. He said, thank you for telling me that this is what I should do. This unity is required. Therefore, there must be a common minimum program, not for the purpose of contesting in the election alone. Whenever the country is in problem, we must join together. And yesterday such a problem came. Last night such a problem came. We also saw that terrible TV pictures. Are we not supposed to join together? Cutting across all political parties, everything, the human beings were slaughtered. Should we not get into one banner and say something? This is where I think the remedy lies in the hands of the citizens. Friends, let me tell you one thing again. I am drawing everything from my emergency. I am sure my good friend Mr. Gurumurthy would also remember this. And when we asked a Supreme Court judge who was superseded, when he came to Madras in 1976, sir, you are such an intellectual, great judge. You could have set at naught everything in the Supreme Court. 5 of you could have done it. Why did you not do it? He just looked at us and he said, judges are also human beings. They reflect the philosophy of the country. They decide the matter. What probably 5 million should go to the street and decide. Do you think 5 judges can decide? This is something for you to do. And that is where the concept that eternal vigilance is the price of liberty. Are we showing that eternal vigilance in every activity of our life? We will have to consider. Above all, I read this word in a particular document, and it said, when democracy gets corrupted, the worst floats atop, the best submerges. Please mark my word. I said when democracy becomes corrupt. I am not referring to when democracy becomes corrupt, the worst flows atop and the best submerges. What we get in our kitty is that worst which floats atop, and that is what we are seeing in our day-to-day life. Again, if any one of you take any book on legal theory, if you read into the beginning pages, Aristotle would have said somewhere, after Plato, Aristotle writes and he says, he refers to 3 different organs. One I remember because as interested in politics, I have read that and I do remember it very vividly. He said in course of time, polity will degrade into democracy. I don't know why he used this word degrade. He said polity will degrade into democracy. Friends, I am worried. If we do not exercise our right of thinking in the right direction on issue basis and take up the matter seriously, we would be committing one of the greatest sins and handing over not a country but a group of dissidents to the next generation. That should not happen. We should exercise our right in the most appropriate manner and take up all matters with some seriousness. This formation of public opinion is very difficult. It is very difficult. It's very difficult to get a crowd beyond this. Even this, I was surprised when he told me that we are going to get a number of attendees today. I was a little surprised. It cannot. But if such small groups really come up everywhere and we discuss, and we take it, percolate it down to the last man in the village and tell him that you are also concerned with this, maybe in another 25 years, we can see real democracy coming up. Today, I'm sorry to say, it is democracy and not democracy that is ruling us. We are in such a bad state of affairs today. But I, as a person, believe this. Originally, I thought we will become great, not Modi ji's word, but in my own assessment, I said that every beginning 20 years of every century and the last 20 years, things have happened. You take 1914, First World War, you come to 1870, Industrial Revolution, 1990 onwards, Computer Revolution, something or other happens. So I thought the time has come for our United States. England has gone, so United States will go down. So we will come up. I also find from our papers that we are going to come up. Initially I thought we will do it by default, but I find that we are doing it by performance, and that is the best thing that can ever happen to us. And therefore, my thinking is, we must take up this matter. I do not know in what form, how somebody will take it to the Supreme Court. This judgment definitely requires reconsideration, and at the same time, the governors should also ensure they do not cross swords at every point of time with the ruling party, with the ruling dispensation. All is said and done, the people have elected a particular government. it is better to find out cordial methods of settling it. If any one of you think that this kind of a problem is something that happened today, once again let me tell you, it was in 1991 or 1992. We had a governor by name Chanakyaa Reddy. Chanakyaa Reddy was always fighting with Jayalalitha. The Madras University Vice Chancellor post became vacant. When it became vacant, Chanakyaa Reddy said that Jayalalitha immediately nominated, said this is a search committee, I am going ahead. She also announced that so and so will be the Vice Chancellor. Governor Chanakyaa Reddy thought it has to be put to a check. So he suddenly called So Ramaswamy and made him his nominee in the search committee. And because of the governor's nominee, he became the chairman of the search committee. Now the problem started on a bigger way. So would not agree with the other persons, there was a problem and there was a stalemate. In order to find a solution to the stalemate, I moved off public interest litigation. One of my good friends who is a chartered accountant who lives in Mahalingapuram with me, I told him, you are the petitioner here. And he told me, "Day நான் நிம்மதியாக இருந்துருக்கேன், என்ன ஏண்டா இதில் இழுத்து விடுறேன், அவள் ஆளை வச்சு என்ன அடிப்படா அப்படின்னா, பரவாயில்ல போட்டுன்னு அவன் பேரில் ஒரு ரிட்டு ஒன்று போட்டோம்." Jayalalitha engaged Mr. Kapil Sibal in that time. Kapil Sibal came to Madras High Court and argued this matter. And ultimately, because of the litigation, some solution came. And so was able to prevail over the other two nominees to some extent. And I think I must share this also with you. Can any one of you make a guess whose name he suggested as a Vice Chancellor in 1992 or 93? I don't remember the year. Our great APJ Abdul Kalam. I remember he said he is one of the greatest persons. If he is not becoming the Vice Chancellor, one day or other, he will be such a great man in India. And mind you, he became the president we all liked, and he was a very lovable person, Abdul said. And second instance when I heard about Abdul Kalam was when I was moving with the army people. I asked them, well, how do you normally recruit people in the officers training and the IAF? They told me, we don't want any great intellectuals. We want somebody whom we can mold. Aptitude is more important. And then he told me this anecdote. Mr. APJ Abdul Kalam wanted to join the Air Force and he was rejected. He was rejected saying that they said that his aptitude was not good for a soldier. So he was rejected, and he told me the irony is he became our Supreme Commander. Vande Mataram, Jai Hind. There is a lot I could say, but then that will become a classroom. Thank you. I hope I gave you some information on this. Thank you so much. Waqf board. That is something which will have to be considered, but nobody can say this property. I was talking, I was in the Justice Bharata Chakravarti's court. So somebody came yesterday, he produced documents from 1880 onwards to show these lands belong to this family of Sengunda Mudaliyars. We perform our Mandagapadi, therefore we must be given the right. The government says it is HRNC is applicable and all. Then the next question was, do you have documents in some other matter, he asked. This point crossed to me. You expect that there, அது கேட்டார் இருக்கடே, அதுக்கு முன்னாடி உங்களுக்கு செப்பு தகடு இல்லைன்னா கல்வெட்டு ஏதாவது இருக்குமே அப்படின்னு கேட்டார். So when you look into the property that there has to be some origin, you cannot. Therefore, these things will have to be considered in its perspective. இதெல்லாம் என்ன தெரியுமா problem? You look into the question without meaning any, offending anybody. The Loyola College is run as a minority institution. Nothing wrong in that. They are entitled to Article 25, 26, everything is there. They can say for religious instruction, it is a minority institution, they are perfectly entitled to. Just as Ramakrishna, you can do that. But when a teacher is dismissed from service, if they come and say, no, this is a minority institution, therefore I am entitled to dismiss them. See, look at it to the extent it goes. Therefore, in all these things, we must see who are the victims. In all these matters, we ourselves become the victims, or the Waqf board, they themselves will become victims because they will say that it is my land, please get out. There has to be, yes, it is very difficult to produce documents for everything, but to the extent possible, there has to be some kind of a tracing of title. Otherwise, why did the British do this entire survey in, I think it started in 1860 or so, 1861 or so. Why did he do this? This problem was there he was facing. Not because he was interested in our welfare. He did not know from whom he should collect the tax. அதுக்காக தான் அப்பாயிண்ட் பண்ணி அந்த கலெக்ஷன் அனுப்பிச்சோம்னா கலெக்டர் ஆகி அதான் இன்னைக்கு ஐஏஎஸ் ஆஃபீஸருக்கு கலெக்டர் அனுப்பிச்சிட்டானுங்க. ரெவென்யூ கலெக்ஷன் தான், அது வேறு எதுவுமே கிடையாது. தட் இஸ் வை தே ஆர் ஆல் கலெக்டர்ஸ். ஹிஸ் ப்ராப்ளம் வாஸ் ஃப்ரம் ஹூம் ஷுட் ஐ கலெக்ட் டேக்ஸ், அவ்வளோதான். தட் இஸ் ஹவ் தி என்டையர் லேண்ட் ரெவென்யூ ஸ்டார்டட். அவன் தான் நமக்கு சொன்னான் இதெல்லாம் இந்த லேண்ட் இதெல்லாம் புறம்போக்கு. அவன் சொன்னது தான் 1905 சுந்தரஜிக்கு எழுதினார் அவர் இருக்காரு. ஸோ ஐ திங்க் we must understand that a law could be a problem to us. The last in the anecdote சொல்ல, 1989 I went to probably that is the last election I campaigned. அப்போது I went to அருப்புக்கோட்டை. அங்கே கேம்பெயின் பண்ணிட்டு வரும்பொழுது 89 I was against the idea of my friend குருமூர்த்தி. I thought that ராஜீவ் காந்தி வந்தால் தப்பே கிடையாதுங்கிற முடிவில் தான் நான் இருந்தேன். இவன் இங்கே வரக்கூடாதுங்கிறதுல I was very particular. ஸோ அந்த கேன்வாஸிங் போன போது I saw a very very elderly man. அவர் எப்படியோ உட்காந்துட்டு படிப்பு அவ்வளோ படித்ததே கிடையாது. அவர்கிட்ட சும்மா கேட்டேன், நீ யாருக்கு இங்கே ஓட்டு போடுவீங்க அப்படின்னு. ரெட்டைலைக்கு தான் போடுவேன். நான் சொல்லி எம்ஜிஆர் தான் இல்லைங்களே அப்படின்னேன். அதனால இல்லைங்க, ரெட்டையில் அவர் தானே கொண்டு வந்தார் அப்படின்னார். எதனால் அப்படி சொல்கிறீங்கன்னு பாருங்கள். நான் பிரிட்டிஷ்காரன் இருக்கும்போது இங்கே பிறந்துட்டேன். அன்னைக்கு எனக்கு கிடச்சது ஒரே ஒரு வேளை கஞ்சி. காமராஜர் வந்தார், எனக்கும் அன்றைக்கி கிடச்சது ஒரே ஒரு கஞ்சி. எம்ஜிஆர் வந்தபோது நான் 2 வேளை சாப்பிட்டேன். அதனால் என் ஓட்டு அவருக்கு தாங்கன்னாரு. தென் இமீடியட்லி மை மைண்ட் ரேஸ் பேக். ஐ ரிமெம்பர் ஹேவிங் ரெட் a beautiful essay by Henry David Thoreau. He wrote in Henry David Thoreau is the person who inspired Gandhi for Satyagraha. So, இன்னொரு பேர் ஏதோ ஒன்று Henry David Thoreau. He inspired Mahatma Gandhi for a Satyagraha. I think he wrote this in 1865 or so. He wrote in his book, the country, the United States became a democratic country in 1776. In all these years, they are yet to pass one legislation which is for the benefit of a common man. அப்படின்னு அவரே எழுதினார். We are no better than that. அதனால் ultimately what you see is how does it help a common man is what we should see. அந்த மாதிரி லெஜிஸ்லேஷன் வருமானு தான் பார்க்கணுமே தவிர would I be affected, my ideology will be affected, my religion will be affected is not the way to look at it. Ultimately we will have to see whether it will affect the common man, whether it will affect his food, clothing and shelter, then on that basis என்ன ப்ராப்ளம் வரலன்னா, அப்போது ராஜா இருந்தபோது எல்லாம் ஓடிச்சுன்னா கன்சியூமரிசம் இல்லை, அவன் டிவி வாங்க வேண்டியதில் ஒன்றும் இல்லை, சாப்பாடு இருந்தது, நிலம் இருந்தது, அவன் பாட்டு உட்காந்துட்டு இருந்தான். இன்றைக்கி அது எதுவுமே கிடையாது நம்மக்கிட்ட. அவர் எக்கானமி இஸ் கம்ப்ளீட்லி டிஃப்ரெண்ட். நான் இதெல்லாம் நிறைய உங்கள்கிட்ட ஷேர் பண்ணிக்கிட்டேன்னா அந்த செல்ஃப் சஃபிஷியன்ட் எக்கானமி, சிட்டிசன்ஸ் ஆஃப் டெமோக்ரஸியில் நாங்கள் போனது வந்ததெல்லாம் கேட்டோன்னா very inspiring. I have seen people. One thing I am very happy that I was a part of this emergency struggle. I was thrown open to several people, cutting across politics, cutting across religion, and I found that there are wonderful people all over. We are not able to connect all of them. That is our difficulty. If we connect them, that is why he said, I have given it to all governors. Read. It is applicable to Kerala. You will have to follow that judgment. 5 நிமிஷம் SLP 2 நிமிஷத்தில் allowed. Until the review or something is filed.
How will they be able to initiate contempt against the governor? You said something. 3 months, 1 month,
இல்லை, ஏன் பண்ண மாட்டான்னு நினைக்கிறீங்க? இதே மாதிரி இன்னொரு ஜட்மெண்ட் எழுத வேண்டியதானே? That is why I told you we must constitution. Precisely that's what, if you read the race and follow the third read, இன்னைக்கு என்னெல்லாம் நம்ம அந்த மாருதி கார் வந்த போதே நான் நினச்சேன், you know how's this Volkswagen என்ன தெரியுமா உங்களுக்கு? This is a German car. The entire world was tottering. 29 depression. 30 Germany was in the worst place because of the reparation of the First World War. All people were seething in anger. Hitler வந்தான் அங்கேருந்து. My common man does not have a car. Therefore I'll manufacture a car now. Folk means folk. FOLK. அதுக்கு அவன் ஜெர்மனியில் VOLK ரைட்டடா? நீ தான் உனக்கு தான் ஜெர்மனி தெரியுமே. Volkswagenங்கிறது it is a common man's car. Now go back to 80 Maruti. Yes. quote this judgment, both you and I will be hauled up for contempt. I will not be surprised by that. But I think we must, that's what I said. 69% reservation is still pending there. Can I tell you something? Our Court Fees Act 1957 was challenged in the Supreme Court. Tamil Nadu High Court Court Fee Suits Valuation Act 1955 was challenged way back in 1957. It remained undecided for the next 40-50 years. It was not decided. You are right. In all those matters, we must go there and say, please hear these matters. There must be a timeline. Don't say about this judgment. You must say there must be a timeline for Supreme Court also. People must realize. No, people must realize. When you fix timeline for everyone, and it's these people who tell us why is all matters are getting delayed in the Madras High Court, we must follow the United States system. You should not talk for more than 15 minutes. He will talk for 15 minutes. Aping Western countries is not going to help us at all. Absolutely not possible. But I agree with you. We must take, sir, since you have been doing this kind of a work, first take out a list of all pending constitutional benches cases. It must be probably any problem. But let us, why not we just take it up? I think voice of justice itself can take. Some important matters, we will move it and say, let the Supreme Court hear it. That is the object. The idea of going to litigation is there is a finality and people just go back and sleep. That's all. They say that I have lost or I have won and be done with that. உட்காந்து நிற்கடுப்பா காலை வச்சு நிற்காத பண்ணி
Can Article 142 can be used to amend the Constitution now? Whether the judgment has amended the Constitution itself or not?
368, that is another debatable, the debatable issue because 368 is indirectly come in. Article 200 has been amended by this without going through the procedure of 368. That is definitely another view. But if you look into it, if you look into the corporate law, when the needle industries case came up, when there was no act of oppression, the Supreme Court said there is no act of oppression. We do not agree with that the foreign investors were oppressed in any manner, but in the ends of justice, we will know what do is, you will buy and he will sell. Then the question came up whether the Company Law Board could do it because they did it under Article 142. Then Company Law Board thought that I am also on 142, they have started applying over a period. It gets diluted. All these things over a period of time gets diluted. Therefore, 142 should be rarely used. Very, very rarely used. But in a country of this nature also, it is quite difficult. The extensive population, everything, it is very difficult to bring everything under one law. But at least we are not a completely judgment law like United Kingdom. No, we are turning into. We are turning into that. United Kingdom is all a judgment law, unwritten constitution, so it keeps changing. But let me tell you, I am just no constitutional expert. I read it because of my interest, that is all. Except that I held a post for, I'll tell you, I was telling Ravi, I was sharing my concern with him personally. When I held a post, when they finding it difficult, the present ruling party, the ruling party, not the government, sought to file a writ petition challenging the transferring of education to the union list in 1976. They asked for that to be brought to the state list. That writ petition is still pending. I told him that is the next thing they will knock and we must be little active in contesting that matter. Because I started arguing, then there was some problem. Then the full bench was not inclined to hear the matter further and we stopped. But that is another thing. Sir, as a person who had to travel because of my father's employment in army till 1966 when I came to Mahalikapuram and settled down, studied in so many places, so many languages, no common syllabus. When I went to North, there was no English at all. When I came to this thing, they were all reading about Shakespeare and I was nowhere, absolutely nowhere. But therefore, there must be, in my view, there must be one common syllabus. It could be in any language. So that a person who gets transferred, all these things are matters which concerns we as citizens, we as parents, and we as students. It concerns a lot. I think some kind of a movement is required. நீங்கள் பண்ணுற அந்த அளவுக்கு பண்ணுறதுக்கு என் சக்தி இல்லை இப்போது. Might have done it about 30 years back, I would have done it. But we require some kind of an active movement and take it up seriously. என்ன ப்ராப்ளம்னா அதை அப்படி அப்படியே மறந்துடுறோம். நம்ம ஒரு விஷயம் நடந்த உடனே அதை தொடச்சி விட்டு போய்டுறோம். மோகன் துக்ளுக்கு சொல்கிற மாதிரி தான். நம்ம கடைசி டைலாக் ஒன்று சொல்லுவோம் பற்றி அதில் தான், ராகவா எனது மக்களை நான் மிக நன்றாக அறிவேன் அப்படி மாதிரி தான். வேறு ஒன்றுமே அதில். பட் இட் ரிக்வயர்ஸ் டெஃபினெட்லி சம் கன்சிடரேஷன் ஸோ தட் வி protect our interest. இல்லைன்னா கம்ப்ளீட்டாக போய்டும். It will be nullified. Thank you.